Tonight, we begin with a moment inside a federal courtroom that legal observers are already calling one of the most shocking breakdowns by defense attorneys they have ever witnessed. Because tonight, Donald Trump's legal team was physically escorted out of a federal courtroom by U.S. marshals after what multiple eyewitnesses describe as a complete and explosive meltdown during a high-stakes federal hearing. This was not a routine objection. This was not a heated exchange. This was licensed attorneys shouting at a federal judge, accusing prosecutors of fabricating evidence, refusing direct court orders, and ultimately being removed from the courtroom in front of everyone. And what triggered this extraordinary scene was a single email, an email Trump's lawyers had previously sworn under oath did not exist. According to reporters from CNN, CBS, and the Associated Press who were inside the courtroom the moment that email was introduced, everything unraveled. Federal marshals stepping forward, a judge openly threatening bar referrals, and attorneys risking disbarment, contempt, sanctions, and potentially criminal exposure, all in real time. That does not happen unless something has gone very, very wrong. Here's how this all unfolded. For weeks, Trump's defense team had centered their strategy on credibility. They argued that any document handling issues were accidental, that Trump relied on legal advice, and that the Justice Department was selectively enforcing the law for political reasons. And until today, that strategy appeared to be holding together. According to earlier reporting, defense attorneys had successfully raised questions about timelines, email chains, and document retention procedures. Legal analysts even suggested that Trump might have had a narrow path toward reasonable doubt on some charges, but prosecutors had been building toward a decisive moment. They methodically laid out document policies. They established timelines through testimony and phone records. They constructed a narrative pointing not to negligence, but to intentional obstruction. And then this morning, prosecutors informed the court they intended to introduce one additional piece of evidence, a newly authenticated email that had been part of earlier document production, but had not yet been presented to the jury. That's when the defense reacted instantly. Before the document was even displayed, Trump's lead attorney stood up and demanded an immediate sidebar. The judge allowed it, and all counsel approached the bench. What followed was supposed to be a quiet legal discussion. It was anything but. According to CNN's legal correspondent, Trump's attorney immediately raised his voice, accusing the government of manufacturing evidence. The judge warned him to lower his tone. He did not. The judge called a recess and removed the jury. And once the proceedings resumed on the record without the jury present, the situation escalated dramatically. Trump's lead counsel accused prosecutors of withholding evidence, committing fraud on the court, and engaging in criminal misconduct. He demanded a mistrial. The judge asked him to specify exactly what he was alleging. And then came the statement that changed everything. He told the court that his legal team had thoroughly reviewed all emails from the relevant period, and that the email just introduced by prosecutors had never been produced to the defense. That claim was demonstrably false. The prosecutor stood up calmly and informed the judge that the email had been produced months earlier in the third document production. She stated it was clearly identified in the production index and then delivered the decisive blow. She handed the judge a copy of the defense's own pretrial motion, highlighted, showing the same email thread number referenced by Trump's attorneys themselves with the damaging portion omitted. According to reporters, the courtroom went completely silent. Trump's attorney did not retreat. Instead, he doubled down. He accused the prosecution of altering evidence after production. The judge, clearly losing patience, asked him directly whether he was formally accusing federal prosecutors of fabricating evidence. He said yes. That was the moment the line was crossed. The judge ordered him to sit down immediately. He refused. He said he would not be silenced and claimed he was willing to go to jail to expose corruption. The judge then looked directly at the federal marshals and said one word: remove him. As marshals approached, a second Trump attorney stood up and began shouting that the trial was rigged and that Trump's constitutional rights were being violated. The judge pointed to him and said, him too. Both attorneys were escorted out of the courtroom as one shouted back that this was a kangaroo court. The remaining attorney, a junior member of Trump's legal team, sat frozen at the defense table. This is not just dramatic. This is devastating, because this incident fits a pattern we have now seen repeatedly. Rudy Giuliani. Sidney Powell, Jenna Ellis, John Eastman. Different cases, same result. Legal careers destroyed after crossing ethical lines in Trump's defense. Legal ethics experts say what happened today could easily be career-ending. Attorneys have a duty of candor to the court. Making false factual statements, then accusing prosecutors of crimes without evidence is among the most serious violations possible. And when a judge issues a direct order and an attorney refuses, removal is not optional. It is required. Now Trump is left in an extraordinary position. His prepared legal team is gone. His defense strategy has collapsed publicly. And the jury has just watched his lawyers get removed for misconduct. There is no good option. Replacing counsel mid-trial would require a continuance the judge is unlikely to grant and would only reinforce the perception of chaos. Continuing with an unprepared junior attorney places Trump at a severe disadvantage against experienced federal prosecutors. Even conservative legal commentators are struggling to defend what happened. Legal analysts across the spectrum agree this was a catastrophic self-inflicted wound. And then, during the lunch recess, Trump posted on social media attacking the judge and praising his attorneys, reinforcing concerns that this behavior was not accidental, but part of a broader strategy that continues to backfire. This moment will have consequences for the trial, for the attorneys involved, and for Trump himself, because when your lawyers would rather be dragged out of court than confront the evidence, the message to the jury is unmistakable. And the fallout from today is only beginning.